Welcome back to another edition of Between Two FARS. I'm Warneke Miller here once again with the amazing Michael Mark and the illustrative Robert Tepfer, and we are continuing our foray into ASBCA litigation. The last couple episodes we've been talking about this important forum and the documents that you need to compile, and now we're getting into the initial motion practice. And we'd like to dedicate this episode to jurisdictional motions, which are incredibly important early on in your case, particularly if you have an inexperienced counsel on the other side or a pro se appellant. So Bob, Michael, kick it off for us. What exactly would constitute a jurisdictional motion in front of the board?
Well, the rules set out specific things you must comply with, whether or not it be filing within a certain period of time, or certain subjects, certain remedies. We were talking earlier, Michael was mentioning the fact that you can't get equitable relief. The rules specifically say you have to have a sum certain, those kinds of things. The issue of fraud is a very delicate issue, which there's a lot of cases on. And so, initially, if you can clearly argue that it falls within that category, and it therefore doesn't merit the board's time and attention, you go there, because a smart lawyer stays out of court, and you don't want to get to the merits on any case if you can avoid it when you're being sued. So those motions go early, and you hope that you've got enough of a convincing case where you can just show in the pleadings that they didn't show compliance with regard to the rules. And that can happen a lot with regard to a pro se that either doesn't understand it or a counsel who is not familiar with this particular form. And when you get there, you file it as quick as you can to save everybody the time and headaches involved. But as quick as you can file it, try to let it get towards the end of the time period so that perhaps they don't have many days to respond. And theoretically, they never did file a claim that merited the board's attention.
All right.
Yeah. Obviously, read the complaint carefully and see what it says. Does it make any sense at all? And we've all seen these stream of consciousness kinds of complaints where it's you hand it to the CO or to the core, and it's, so do you understand what they're talking about? No, none of that ever happened. And verify it, and then file your motion. I was mentioning I had a case when I was in the Air Force one time where it was an inexperienced counsel. And first he seemed to want, equitable relief and, basically specific performance, which we can argue whether the board can do that or not. I don't think they can. And well, eventually we denied the claim after we met with them and tried to explain to it. And of course, the denial of the claim tells them what their appeal rights and times are. So we waited the 90 days. They did not file at the board. And they filed at the Court of Federal Claims 13 months after the claim was denied. So that was an easy one to file a motion for summary or to dismiss. Didn't need summary judgment, and it was granted. So those are things that can make your life much simpler. But you've got to try to understand what's in that complaint. And Bob pointed out with pro se, particularly, the board will often kind of stretch things to try and accommodate. Well, they're not lawyers, and they don't understand all of that. So the board will kind of cut them a little bit of slack. But nevertheless, if the thing is completely incomprehensible, at a minimum, you ought to be saying we need a more specific complaint. How do we answer this thing? It's either
there's that motion for a more definite statement. I'll see if I can pull that up here.
Yeah.
There we go. Yeah, so that's down here in Rule 6.
Right.
And that is very helpful with pro se, because I think there are times when the board judge probably appreciates that as well, to get a clearer idea of what it is the pro se appellant is seeking. Because the rambling narratives are not only very hard to construct an answer for, it's, I think, hard for the board to get their arms around what it is they're being asked to adjudicate.
Right. And of course, if they can't figure out what to adjudicate, how are we supposed to respond to the thing? So there is that challenge. But again, it all goes back to what the pleading looks like, and can we knock it out? I agree with Bob. If you can possibly get rid of it on a motion like this for dispositive, there's no jurisdiction. It may be also that they're alleging things that either the contract doesn't provide for. Not every clause in the contract is a remedy granting clause. And sometimes they're saying, well, you didn't do something with your appropriations. You're using the wrong color money. Well, that's not for the purpose of the general public, and the board shouldn't be taking those cases on. They don't adjudicate that kind of stuff. So you need to look at that and see if we can knock this case out at the very beginning.
Yes.
All right. I would just like to, any new attorney that is going against a pro se, I want to emphasize the worst cases that you can possibly have involve a pro se, because what will happen is the judge, in an effort to give that individual a day in court, will become their counsel. Mm-hmm. And it is no fun to stand up in court and tell the judge that they've got the law wrong or they're misinterpreting the contract, which is precisely what you may have to do. So be very, very careful of a pro se who sits there and looks to the judge, Your Honor, it's our only business. We didn't understand this. And the judge becomes the advocate. You don't want to have that happen. So take it very seriously, notwithstanding the fact there's not another lawyer in the room besides the judge.
All right. So as we wrap this episode up, I'm going to try to have a card come across and list some of the jurisdictional subjects that you would want to think through at the beginning of your case. We talked about timeliness. Did they appeal the contracting officer's final decision in the right amount of time? We talked about subject matter jurisdiction, which is pretty broad. That could include allegations of fraud. That's an area that the board won't look at. You guys also mentioned specific performance. That's something you should really scrutinize and see whether or not what they're asking the board to do is something that they can actually do. Michael also mentioned when they request something that's just not a right underneath the contract, some internal procedure regarding color of money or something that is just not within the board's jurisdiction. What other issues should we be thinking about when we're thinking jurisdictionally? Should this case even be here? What about, was there a contract to begin with? Was there a contracting officer's final decision? We've got some of those very basic stuff that would, I guess, be obvious, but I'll throw them up on the list here.
That's not as obvious as you might think, because a lot of times, particularly with a pro se, they will start raising issues never were adjudicated in the final decision. Mm-hmm. And that would be immediate action that I would go to and say, where did you ask this question? The clock is still running on that aspect. And why is this in any way, putting us on notice of those issues?
Good. Yes.
Yeah. That's a good point.
All right.
Yeah,
Lots to think about.
It's already assuming the contract was there, but you're right. There may or may not be one.
Well, it depends how pro se your pro se appellant is.
Well, I think where you could see this is in the context of unauthorized commitments, ratifications and things of that sort, where somebody said, will you fix my computer? And then we get a bill and the contract officer says, I'm not going to pay it. And theoretically, you could get a claim out of that. But again, because it's an unauthorized commitment, there is no contract. The board.
Oh, there is. It's just with the individual who told them to do it.
Right. It's not with the government. Let's put it that way. It's one of these implied in fact versus implied in law. And so there, you're right. There may not be an actual contract in place, and that does happen from time to time.
All right. And we're just getting started. Isn't the ASBCA just so much fun? It's like a game of monkeys.
Speak for yourself.
Stay tuned for our next edition of Between Two FARS, when we'll dig even deeper into this really exciting and interesting area of litigation. Until next time.